From supplementary list, item number 1.
Supplementary.
In this case, the petitioner's land was acquired by the government for the construction of the William Nagar township, and about 1600 bighas were taken, and compensation was paid for that. But at the time of taking possession, about 377 bighas of our land was taken by the government. So we represented to them that please survey it, it is extra. They did not agree. Finally, we filed a writ petition before this.
You're on the other side.
My lord.
Yes. You're for the state.
Yes, my lord. I'll be.
Yeah, there's a delay.
My lord, this relates to the land acquisition proceeding which has already initiated in the year 1960s, my lord. And thereafter, the writ petitioners, they are trying to agitate, which is already disposed of matter, my lord, after 30 or 40 years, my lord. So, hence, single judge.
Yes, the ground is at paragraph 25. Approach the forum after a gap of 27 years.
Where, my lord?
Paragraph 25 of the impugned judgment. After 27 years, even Rip Van Winkle dies after 27 years.
My lord, here the thing is that the award was paid in the year 1993. And it was after the award, then they started encroaching the land. And they are counting from the day of section 4 when it was notified, my lord. It is not like that. It was somewhere in the year 2002, 2003 like that. The encroachment took place. And that is why we represented to the government and they did not respond. And finally, we came to the High Court.
Come to paragraph 20. Your predecessor's interest was present at the time of survey.
It is in respect of the land, 1600 bighas, for which compensation has already been paid. At that time it was surveyed, and I am not saying it at that point of time they have taken, but after the award was given, then slowly they proceeded and it was about 377.
That we cannot accept. No.
But we have already surveyed the land and we request the government that if you are not satisfied, then you also survey.
Why should they do it?
My lord, there is no harm in surveying the land.
No. You put in 1 crore of rupees, they'll survey. Deposit 1 crore of rupees.
So,
and when we find that you're ultimately it's worthless, we'll forfeit half of that.
But my lord, in that even my survey may be accepted, which was.
Why should your survey be accepted? Who are you to survey? I'll go over there, I'll survey, I said I've conducted a survey. Who are you to survey? No, we won't entertain it.
So, my lord, in that case, the appeal will be deprived
of about 284 days, 254 days in preferring the appeal is condoned in view of the good ground shown. Paragraph, however, it appears that this appellant is given to making claims after an inordinate delay, full stop, indeed, the writ petition carried before the single bench was dismissed on the grounds indicated at paragraph 25 of the impugned judgment and order of September 2, 2022, set out, paragraph 25. Paragraph. On facts, The court found, inter alia at paragraph 20 of the impugned judgment, that the predecessor interest of the writ petitioner was present during the survey of the land on March 19, 1984 and appended his signature along with 16 others, full stop. The total amount of land that was a part of the survey was shown as 5803 bighas, though the land of the predecessor interest was slightly over 1618 bighas. Paragraph. The appellant seeks to claim that the appellant is not aggrieved by the original acquisition or the quantum of compensation paid therefor. Full stop. The appellant seeks to make out that subsequent to the original acquisition, the state has taken possession of excess land, and a survey conducted at the behest of the appellant established the same. Full stop. Paragraph. Since the original acquisition was in 1984, and the appellant claims that the subsequent acquisition may have been in 2002 or 2003, even if the appellant's statement is accepted, there would be gross delay on the part of the appellant to approach the court, full stop. Paragraph. The trial court has referred to several judgments relevant to the context. Particularly of the Supreme Court, that instruct that delay and laches should not be lightly brushed aside, even though the law of limitation may not strictly apply to the writ court. Full stop. Paragraph. Considering the reasons furnished in the order impugned and the gross delay and laches on the part of the appellant to approach the authorities and the court under Article 226 of the Constitution, there does not appear to be any merit in the original claim and no reason to interfere with the judgment and order impugned dated September 2, 2022, paragraph WA so-and-so is dismissed, the MC is disposed of.
My Lord, I may be allowed to submit that there are two judgments of Supreme Court 22 and 23, similar institutions.
They are cited before the Supreme Court itself.
No, my Lord, in this judgment, those have not been cited. Those have not been quoted.
Before the Supreme Court. Show us the ground that you had shown those judgments and they have not been cited. Show us the ground in the memorandum.
No, I am not saying that. Before the judgment, that judgment came from Supreme Court, even 23, my Lord.
Thank you.
From the main list, item number 1.
So the respondent.
I am appealing for the respondent.
Yes. Yes, Dr. Saraf.
This matter in fact came up earlier also before Lordship.
Yes. What is the point involved?
Well, the point was that the penalty was imposed for the short lifting of the coal by the respondents.
Yes.
The specific quantity was to be lifted, and there was a short lifting of the coal because of the abnormal increase in the prices. And for that, the fixed amount of the penalty has been imposed, although the context says of the compensation, although the said coal was sold by the appellant company, and the contention of the petitioner is that, my lord, since the clauses speaks of the compensation, and thereby till there is a loss, the compensation cannot be, my lord, claimed by the appellant company. The learned single judge, my lord, accepted the contentions of the petitioner, that the respondent, and set aside the, my lord, the imposition of the penalty by the appellant company.
Yes.
My submissions before lordship, my lord, before appellant stage, my lord,
Yes, sir.
that, my lord, that the law on the point is starting from Fateh Chand, my lord, is that, my lord, that is the maximum amount which is prescribed for the section 74 for imposition of any penalty or something. But if the amount cannot be determined, then also it must be a reasonable compensation. It cannot be the amount fixed by the in the contract itself, because that's the maximum amount which can be claimed. Now, in this case, admittedly, my lord, the amount, the coal having been sold, so it cannot be said that the amount which is fixed in the contract can be said to be the, my lord, the loss which has been suffered by the appellant company. More further, my lord, the appellant has not given any detail, anything that what was the loss suffered. If in that case, my lord, assuming, my lord, worst to worst, it cannot be the amount which is fixed in the contract itself. It can at best be the reasonable compensation, which a lordship may in the facts of the case fix the amount, because
Yes, Mr. Ahmed.
Worship. In this case, you will remain issue involved is, first of all, whether the writ lies. On last occasion, your Lordship also indicated that perhaps it does not lie. Because they've laid a claim in a contractual matter of a certain amount without giving the details there. And unless the loss is proved by either party, which cannot be done in a writ court, the matter should go to the civil court. That is the crux of the matter.
Now, you have only made a monetary claim.
Monetary claim.
After that, have you taken any other steps?
No.
You've just made a claim.
Made a claim.
You've not imposed any penalty, or
We have imposed penalty.
you've imposed what kind of penalty is that?
Penalty as per clause of the agreement itself.
4.5. No, the moment you call it penalty, you are in
Compensation, that is the word.
yes. Compensation you are entitled to, but in Indian law you are not entitled to penalty.
Penalty, true.
You are entitled only to compensation.
And termination of contract.
Hang on. Today.
Base 145A.
Dr. Saraf,
My lord.
now we remember that how are we going to assess the Payana Paisa? We'll relegate you to suit.
Our specific.
Well, I will submit it this way, my lord.
That loss
That is subject to your lordship's consideration, my lord.
Yes.
My lord, earlier I filed a petition before this court, and this honorable court allowed the application, against which, my lord, an appeal was preferred by the appellants. And after hearing the law, my lord, for detailed hearing, the division bench held, my lord, that let it go to for the first for settlement between the parties, and thereafter only if the settlement is not in the
No. We are not settlement judges. No.
No, my lord, the matter,
We are more decisive than settlement. We will say that in such a scenario, how will we assess what is the quantum? We accept your point in principle that compensation has to be as a compensation for the loss suffered. You cannot make a profit out of compensation. You have to demonstrate what is the quantum of loss. Yes, there is a liquidated damages clause or there is something. Ordinarily, that is taken as a genuine pre-estimate. But in a case of shortlifting, when they have subsequently sold it, then they are entitled to the difference in price and the additional cost that they have incurred for undertaking that exercise. That's all that they are entitled to. So in principle, we accept that. But how are we going to assess that amount?
My lord, I will
That is not something which we will do in a writ court.
No, I'm submitting this, my lord. The courts have held, my lord, even the constitutional bench, that in case the figures are not there and is not estimated, a reasonable compensation can be given. Now, reasonable compensation.
No. We are not on that. We'll refer to that and we'll say we don't agree. No. That's not the duty of the writ court to do.
My lord, my submission before Lordship will be there, my lord, that since the matter is going on for so long, my lord, for many years, the matter is going on.
You've taken a chance. You've taken a chance. Matter whether a writ petition was filed in 2018, you've taken a chance, and we'll say this is not a matter, and they will not take a point of limitation.
This was not filed in 2018. This was 2018. The second petition was there. The first petition was filed much before.
Maybe whenever the first petition may have been filed, we are dealing with only this matter. We'll not go into the first petition. We'll give you leave, and we'll bind them. We will bind them that they will not take the point of limitation. In any event, we'll say that you'll be entitled to make your entire claim.
Well, my submission for subject to lordship convenience,
yes.
Because when we go to temple, my lord, we make all prayers, my lord, whatever is there, and it is for the God to, my lord, to whatever things we to give. And we are also here in the temple of justice. My submission before the
Indian practice, Mr. Dr. Saraf, is that the more you sin, the more you wrong, the more the quantity, the basket of gifts that you throw at the God to atone for it.
No, my lord, the something will be pray that my submission.
Number one. Number two is that we don't want to deify justicing. Justicing is just a constitutional work. It's not an act of God that we are discharging. So,
whenever lordship is sitting here, we take it that your lordship is sitting as a God, my lord. Either never in the temple of justice, you are just like a God, my lord. My submission for lordship is, my lord, the lordship may fix a reasonable compensation, whatever lordship is thinking fit, and may put an end to the matter. Otherwise, my lord, the matter is hanging from 2009.
It's something that we cannot assess, and depending on whatever gas balloon you make us sit, ultimately is going to be punctured.
Lordship has earlier also done it.
Let us see the previous division bench judgment. You can't assert in this. And it's only here that, Coal India Limited government company, its money is lost for 20 years.
In fact, with due respect, the government of India's money has not been lost. In fact, I am in trouble, my lord. The government of India has got whatever they should get, my lord.
224.
224.
234.
224 of the paper book.
224.
224. No, where's the operative part?
$231A.
$230A. Clearly, parties deserve to be directed to take recourse. Is there a settlement mechanism over here?
Yes.
That's why I availed of.
Very well. When the parties are delegated to the order, it does not enhance the order impugned and all. Make it clear that the opposition. Then, if settlement fails,
My lord,
if settlement fails, what is the answer?
page 232, my lord.
If the settlement fails, then what is the remedy?
Remedy is said to take recourse to the legal remedies.
It's the same remedy that we are asking you to take.
My lord. My lord, my submission only before your lordship is there, that thereafter I leave it on lordship, my lord. Absolutely, my lord, the Coal India is also not benefited 2009 onwards. They are, my lord, fighting the case. The petitioner is also fighting the case.
Yes.
So what
Where is the impugned judgment, Mr.
Yes.
Ahmed?
305. Page
Page 305.
Page
305
305 at
memo of appeal.
of the memo of appeal
Paper book.
yes
in a paper book.
26/10/2022.
Yes.
The appeal is directed against a judgment and order of October 26, 2022, passed on a writ petition instituted by the respondents herein. Full stop. Paragraph: the grievance carried by the private respondents to the writ court was that in terms of a coal supply agreement, the private respondents were required to lift a certain guaranteed amount of coal periodically, but they failed to do so, following which the appellant herein raised a claim for such minimum guaranteed amount. Full stop. It also appears that some bank guarantees may have been furnished by the private respondents as part of their promise to lift the minimum guaranteed amount. Paragraph. The legal question that the private respondents raised before the writ court was as to whether the private respondents would be liable to compensate the appellant herein for the value of the quantum of coal that was not lifted, particularly since such coal was sold to a subsequent purchaser. Full stop. The private respondents asserted that a party could not make a profit by claiming compensation, as compensation, implied only to make good the loss suffered by a party. Full stop. Paragraph. In principle, the private respondents appear to be right. Full stop. Since the relevant clause cannot be read as a penalty, as that would be ultra vires the Contract Act 1872, as that would be prohibited by the Contract Act, not otherwise, the minimum guaranteed amount or the value thereof can be seen to be a measure of liquidated damages indicating the highest amount that the appellant herein could have received for the private respondents not lifting the quantum of coal that was specified in the agreement. Full stop. It also has to be accepted, paragraph, it also has to be accepted that if the coal, if the amount of material not lifted by the private respondents was subsequently sold, the amount realized on such account would have to be deducted from any claim for compensation that the appellant may have. Full stop. However, the appellant would be entitled to the additional costs incurred in conducting the second sale. Paragraph. It is quite common, particularly in the international grain trade or in case of high sea sales of commodities, that a party agrees to purchase a certain quantity of goods but reneges on the same. Full stop. In such a scenario, as per the law in force in this country, notwithstanding any agreement between such parties, the party in breach would be liable to compensate the other party only to the extent of the loss suffered by such other party, unless there is a genuine pre-estimate indicated by way of liquidated damages. Full stop. It often happens that the price of the commodity goes up and the party who had contracted to purchase the same originally is no longer finds such price to be commercially viable. Full stop. In such a scenario, the seller may sell the same commodity at the risk and cost of the original buyer to a third party, but it is only if there is a shortfall in the price that such shortfall can be realized from the original buyer. Full stop. Of course, the additional costs incurred would be to the account of the original buyer. Full stop. Paragraph.
In this case, there was increase of 60% in 1 year below the price.
May have been.
I'm just
At the end of the day, it is a question of calculating the quantum of compensation that the party not in breach is entitled to by taking into account the original price of the product, the price at which it was sold to the subsequent purchaser, and the costs incurred in conducting the additional exercise. Full stop. It is a matter of evidence where accounts have to be gone into, and such exercise cannot be conveniently conducted in course of proceedings under Article 226 of the Constitution, since writ proceedings are heard on summary basis and on affidavit evidence alone. Paragraph. The private respondents referred to a previous order of this court in similar circumstances rendered in, when did it begin? 218?
224.
224.
224 of the paper book.
224 of the paper book.
Sorry.
In respect of the same parties, my lord.
Rendered in WA1 and WA2 of 2014, bracket, Chairman Coal India Limited versus Cement Manufacturing Company Limited, or WA1 of 2014 only. Full stop. In such case, the court observed that there were several contentious issues that could not be conveniently adjudicated in proceedings under Article 226 of the Constitution. Full stop. The appeals were disposed of by requiring the parties to take recourse to the settlement mechanism provided in the relevant agreements. Full stop. The observations in the judgments impugned before the division bench were required not to be taken into account for the settlement purpose, and certain bank guarantees were required to be kept alive till such time that the settlement negotiations continued and even thereafter. Full stop. What the judgment, paragraph, what the judgment of the date is
29/9/2016.
September 29, 2016. It should be there on the first paragraph. What the judgment of September 29, 2016 does not expressly record pertains to the remedy that may be open to the writ petitioners in that matter upon the settlement mechanism failing. Full stop. Clearly, in view of the observations in the order that there were contentious issues that could not have been conveniently adjudicated in summary proceedings, the private respondents, the writ petitioners in that case would have had to make a claim by way of a civil suit, bracket, or if there was an arbitration agreement, by an arbitral reference, bracket closed. Full stop. Paragraph. Accordingly, since the parties agree that the coal supply or fuel supply agreement in this case provides for a settlement mechanism, the parties are relegated to such mechanism. Full stop. All observations and findings rendered in the impugned judgment and order of September of
My lord, in this case, settlement has already been done, my lord, as per the direction of the court, my lord.
in this one.
In this case, my lord, the earlier judgment was also in respect to the same parties, my lord.
Yes.
And after that, the settlement proceedings were done. And after the settlement has failed in respect of them, the petition was further filed, my lord.
So this petition is as a result of that.
result of that, my lord. The earlier one was also.
According, cut it out. Full stop. What did I say? Clearly that, repeat that. There's a sentence beginning clearly in the previous paragraph.
Clearly, in view of the observations in the order that the contentious issue that could not have been agitated in the following
Disposal order.
to the file of a civil suit or the application accordingly.
Full stop. Then. It was no longer open as a result of the previous order, it was no longer open to the private respondents to approach the writ court once again with the same claim upon the settlement mechanism failing. Full stop. What was not clearly spelt out in the previous order of the division bench was that should the settlement fail, the parties would have to approach the matter in accordance with law, and the writ court was not the proper forum for going into such contentious issues. Full stop. Paragraph. Accordingly, the judgment and order dated, impugned herein dated October 26, 2022 is set aside. Full stop. The private respondents are directed to keep all bank guarantees alive for a period of 3 months from date. Full stop. It will be open to the private respondents to file a civil suit in respect of the claim, whereupon the further continuation of the bank guarantees will abide by any interim order that may be made in such civil suit. Full stop. It is made clear that since the matter was pending before this court for a long period of time during the 2 sets of proceedings, the appellant herein will not urge the ground of limitation, and the private respondent suit, if filed within 6 weeks from date, will proceed to be adjudicated on merits. Full stop. Paragraph. This order is without prejudice to the rights and contentions of the parties, and they will be entitled to urge all grounds available to them in accordance with law before the appropriate suit court. Full stop. WA number so and so is allowed to the extent indicated above. There will, however, be no order as to cost.
Second to same.
Second also will be the same, below.
Second also the same. In view of the order passed in similar circumstances in another appeal, give the appeal number, the same order is made herein. Full stop. Paragraph. Just set out the operative part of the order over here once again. Thank you, sir.
Item number 3.
Thank you, please. Thank you.
Please, Your Lordship. This is this custodial violence that matters, Your Lordship.
Yes.
On the last occasion, Your Lordship, on 3/5/2023, Mr. Mozika had submitted the report, and this Honorable Court was pleased to grant us 6 weeks' time. Lordship, the matter is under active consideration, and we need slight accommodation more, Lordship.
When should we keep it?
Lordship, 6 weeks.
Next week?
Six weeks, Your Lordship.
Very well. Since the state submits that the issue of enhanced compensation is under the active consideration of the state, let the matter stand over for 6 weeks.
A pleasure.
It's your pleasure.
You're also appearing, madam?
Yes, Lordship, I'm appearing for respondent 15 and 18.
Who are they?
They are the Lordship,
They are the families.
families of the.
Thank you.
Any mention for unlisted matter? Any mention for unlisted matter? From supplementary list, item number 1.
May it please, Lordship.
Yes.
This is an appeal under Section 37 of Arbitration and Conciliation Act, my Lord, against the final award passed at the interim stage.
Final?
Award at the interim stage. There were two claims which were pressed by the contractor, my Lord. One was with regard to payment of interest on delayed payment, interest on delayed payment of labor cess, interest on delayed payment of extra bitumen, my Lord. So this was the interest claim which formed part of Dispute Resolution Board, Review Board, which we call it DRB1, my Lord. The second claim was pertaining to, my Lord, delay, disruption and prolongation, for which the matter is still pending before the arbitral tribunal, my Lord. The facts of the case are, my Lord, in brief is that in 2011, Government of India, Ministry of Road Transport Highway invited bids for expansion of the road, the two-way of Shillong-Nongstein and Nongstein-Tura National Highway expansion to Leni, my Lord. The bid of the contractor was accepted, which was of 1,303 crore rupees, my Lord, which was by supplementary agreements enhanced to 2,400 crore rupees. The dispute arose between the parties with regard to payment of interest on delayed payment. Various IPCs payment were made, my Lord, time to time, which was referred to Dispute Review Board, my Lord, in 2016, my Lord. And the claim of about 82 crore rupees was made before Dispute Review Board, my Lord. Dispute Review Board recommended payment of this amount of 82 crore rupees in favor of claimant. Before Dispute Review Board, my Lord, the stand taken by the government is this, that the interest component has been subsumed in enhancing the contract value time to time, which was enhanced to 2,400 crore rupees. So you are not entitled to interest, my Lord. Secondly, it was also taken before the Dispute Review Board, my Lord, that
Dispute Review Board is the arbitral tribunal?
No, it's not the arbitral tribunal. It's consisting of engineer nominated by me, contractor, and in turn by Indian Road Congress, my Lord. Dispute Review Board again reviewed this decision and also awarded interest on interest at the rate of 12%, my Lord. There was a negotiation going on between Ministry of Road Transport Highway. The Government of Meghalaya is executing agency. The tender was invited by MORTH, but I signed the contract, my Lord. And our case is that MORTH is a necessary party we place before the arbitral tribunal. I will take your lordship to that aspect separately. What has happened? Dispute Resolution Board negotiation was going on as to the claim. Government of India, MORTH agreed to pay the payment with regard to labor cess and extra bitumen. These two components out of three recommendations, my Lord. One recommendation was with regard to interest on delayed payment. Second recommendation was with regard to payment for use of extra bitumen and reimbursement of labor cess. So far as reimbursement of labor cess is concerned, and labor cess, my Lord. Labor cess was a claim, separate claim, my Lord, and use of extra bitumen. So far as use of extra bitumen and labor cess is concerned, recommendation of DRB, Dispute Review Board, was accepted. So far as payment of interest on late payment of various installments was not accepted. Second aspect, because there was no claim before DRB with regard to payment of interest on delayed payment of labor cess, on delayed payment of extra bitumen. So interest was imposed by way of review by DRB without any authority, and that interest component has not been accepted by MORTH, and in turn, so the whole claim with regard to DRB1 is interest on delayed payment, my Lord. That negotiation was going on between the parties. At one point of time in 2018, claimant sought to nominate his arbitrator with regard to this dispute. That happened on 11th June 2018, my Lord. Then on 18th June, Government of Meghalaya said that we will challenge this decision before appropriate proceeding.
Then on 20th June, there is a meeting held between the contractor, Government of Meghalaya and MORTH in 2018, my lord. Then contractor decided to revise his claim and he made a revised claim in November 2018, my lord. This happened with regard to interest payment, my lord. Then thereafter, in the meantime, my lord, in 2018, second dispute was raised with regard to delay, disruption and prolongation, for which recommendation came, and recommendation came by dispute review board to make the payment of 250 and odd crore rupees, my lord. This was decided to be challenged in consultation with MORTH. MORTH appointed Mr. K.K. Jalan IS as nominee arbitrator for MORTH and Government of Meghalaya, my lord, with regard to DRB, two claims only, with regard to delay, disruption and prolongation. This was intimated to the claimant, my lord. Claimant said, since the payment in respect of DRB 1 has not been made, I am referring this dispute to Mr. Jalan, and claimant also nominated Mr. R.K. Srivastava IS as arbitrator, my lord. When the matter came before the arbitral tribunal, and both the learned arbitrator appointed Justice V.V. Gupta, retired Delhi High Court judge, as the presiding arbitrator. When matter came before the learned arbitrator in 2019, my lord, the claimant filed the claim, and in claim both claim relating to DRB1 and DRB2 got included, my lord. We moved the application before the arbitral tribunal under section 16, saying that the dispute pertaining to DRB1 has not been referred to this tribunal. Mr. Jalan was never appointed as arbitrator for DRB1 dispute. You could not have unilaterally referred the dispute to DRB, this arbitral tribunal. My application and claim is barred by limitation, my lord. My application under section 16 was dismissed by the arbitral tribunal, stating that there is a implicit or tacit agreement to refer the dispute to DRB1. The tribunal also returned the finding that the limitation is mixed question of law and fact, which will be examined at the time of merit with regard to examining the claim on merit. The Lordship, one more application was moved, and along with the statement of claim, that is application under 31.6 application under section 31.6 awarding the claim of DRB1 on the ground that there is no challenge to the decision of DRB within 28 days, and contract provided that if the decision is not challenged within 28 days.
And how was it to be challenged?
This has to be challenged. The agreement provided, my lord, that the first dispute has to be raised by the contractor before engineer. Engineer is required to take a decision within a period of 14 days. If he fails to take a decision, or if he has taken a decision which is against the contractor, contractor will refer the dispute to dispute review board if the claim is more than 50 crore. If the dispute review board, my lord, fails to decide the matter within 28 days, or if it decides the matter and it is not challenged, the decision of dispute review board will be final and binding, my lord. Then there is a mechanism provided that the claimant will seek to appoint his nominee, I will seek to appoint my nominee, and both of them will appoint third nominee. If they fail to appoint, then Indian Road Congress will appoint the presiding third arbitrator. So there was this procedure which is laid down in the contract with regard to DRB1 dispute was never followed.
No, but you said DRB if challenge within 28 days,
yes, sir,
it will become final.
A final binding.
But so, then there is no need to go to arbitration then.
There is no, then it has, that is our case, my lord, that if it is not, there is no need to go to the arbitration. This has, because the arbitration mechanism got exhausted, and therefore the matter has to go to the civil court or appropriate court for recovery of the amount, my lord, because decision taken by DRB is not challenged, would not amount to saying that that decision you have no right in law to challenge it in accordance with law. And I raised that issue, my lord, before arbitral tribunal. Arbitral tribunal said, yes, this issue is writ large before us, we will decide this matter, and since this matter is pending before us, we will decide the matter. That is the order passed in section 16. When 31(6) application was allowed, my lord, without on the ground of Order 12, Rule 6, that now you have not challenged, and there is some admission before DRB. Therefore, this amount claim of 117 crore rupees, out of 117 crore rupees, 75 crore rupees is awarded. And the arbitral tribunal also held, since we have already decided all the issues in section 16, we will not go into the issues at the stage of 31(6), my lord. While deciding, while my application under section 16 was dismissed, tribunal said we'll examine all these issues, limitation, etc. while deciding 31(6) application. And in 31(6) application, tribunal says, my lord, that since all these issues I have decided in section 16, I will not examine all these issues in 31(6), my lord. This is the one aspect of the matter, my lord. There is some further development which has taken place. I challenge this. I moved one more application for impleading MORTH as party, my lord. Because MORTH is necessary party, that application was dismissed, my lord. I separately challenged that application under 37 before Learned District and Session Judge, Commercial Court, my lord. In the meantime, because the claim pertaining to DRB 1 was of 117 crore rupees, my lord, and 75 crore rupees was awarded by final award, so the arbitral tribunal became functus officio so far as claim number 1 is concerned, my lord. Despite giving the award on 117 crore rupees, my lord, arbitral tribunal again, while adjudicating the claim number 2, DRB 2, my lord, framed the issues whether the claimant is entitled to 117 crore rupees or not. This framing of issues, my lord, was objected to me by saying that it is now your functus officio. I have already challenged this part of the award under 34. Therefore, you can't go into this issue, my lord. The arbitral tribunal decision to frame the issue was challenged by me under Article 227, and my writ was allowed by this honorable court.
Yeah. 227 is not maintainable.
Yes, Lordship. What has happened now, thereafter some the incomplete, that issue is not before your Lordship. What has happened, that was challenged before the Honorable Supreme Court. Matter is pending before the Honorable Supreme Court, and the arbitral tribunal, so far as claim number 2 is concerned, is stayed, my lord. So far as that part is concerned, my lord. But at this point of time, the Lordship, we are concerned with this issue of 2 orders passed under section 16 and 31(6), my lord. These 2 orders are challenged, my lord. I have prepared the convenience compilation containing all the documents and everything before your lordship.
And what did the trial court say?
Trial court says that since the 136-page judgment, 5-line, my lord, since the arbitral tribunal has dealt with all these issues extensively, therefore we will not go into all these issues. So there is no hearing at 34, my lord. There is no examination of my points, my lord. Only 136, my lord, total pages judgment, my lord, and 5-line, my lord. That since the tribunal had extensively dealt with the objection under section. Beg your pardon, my lord. Page 177 is, my lord, the finding of the paragraph 55 at page 177. Paragraph 55 at page 177, my lord. Fifty-five, 56, my lord. and then 59, my lord, at page 192.
So the DRB said 117.
The claim was of 117, DRB gave 75, my lord. And DRB gave, and then they moved 33 applications saying that award is not clear, is inchoate. Why have you given us 75 crore rupees? You correct the award, and then arbitral tribunal dismissed 33 applications, my lord. If I can show the award.
That's all. So they maintained
75 crore rupees. 75 crore rupees is the amount given finally out of 117 crore rupees, which is nothing but claim of interest, my lord. And which, according to me, my lord, as per us, it has been subsumed, my lord. I have prepared, my lord, all relevant pages and volume. So I can show, my lord.
No. In the absence of your challenge to the DRB decision, you have no legs to stand.
Lordship, for that I have to show, my lord. They kindly see that DRB decision was to be challenged by way of suit, my lord. Because if the mechanism 28 days is the window within which I can invoke arbitration, my lord. And I urge this issue, my lord. I raise that issue, my lord. That
Let us see the clause.
Yes, lord. 246 of. Please pass on this. These are.
Who is appearing for the contractor?
Mr. Ranjit Prakash.
I am Lordship. I am appearing for the KVT respondent for the contract. May I just make a few submissions, Your Lordship, while you are going through certain documents?
Please wait.
Yeah.
255, my lord, of the volume 1. It starts from 255, my lord, conditions of contract, and relevant is at page, my lord, 262. $24 million at page 262.
Where is your notice within 28 days?
There is no notice by either party, my lord, in both the cases.
So both the parties have accepted it.
So, my lord, so far as this 28 days, if your lordship will see, if the dispute review expert shall give a decision in writing within 28 days of receipt of notification of dispute. Dispute review expert shall be, now your lordship will see the 25.3. 25.2, my lord, sorry. Dispute review board shall be paid on so and so rate, not relevant, my lord. Either party may give notice to the other, refer a decision of dispute review expert to an arbitrator within 28 days of dispute. Review expert's written decision. If neither party refers the dispute to arbitration within next 28 days, dispute review expert decision will be final and binding, my lord. Now 20.25.3. The arbitration shall be conducted in accordance with arbitration procedures stated in the special conditions of the contracts. Then, my lord, the special conditions of the contract is at page, my lord, 274, my lord. D, my lord. Missing no. And then, my lord, kindly see the letter.
Where is the arbitration covered by the special provisions of the contract?
That is at page 274D, my lord. Lordship has that page in the volume, my lord.
274 we have.
274 A, B, C, D, my lord. Those.
No, we don't have.
Because that is the special condition of contract, my lord.
Mr. Prakash,
Please, Lordship.
please tell us, why will this abridging of time not be hit by Section 28 of the Contract Act?
I will just tell you, Your Lordship, I think you've not been told the complete facts. Now,
No, we don't want to know the complete facts. We don't want to know the complete facts. All that we are asking you is that there is an abridging of the period of limitation in clause 25.2. Now, why should that not be seen as contrary to Section 28 of the Contract Act?
I'll tell you, Your Lordship. The limitation which is prescribed in the contract within 28 days, within which the arbitration was to be invoked. Now, what happens in this case is that the DRB1 claim, which was admitted repeatedly by them, I'm not getting into the merits because Your Lordship under 37 will not enter into the merits, but just to give you a brief idea, that the matter went on, they discussed this issue of DRB1, they finally asked me to offer some...
We have a very simple question. We are not on the merits, we are not on what DRB did, we are on the clause. The clause says either party may give notice to the other to refer a decision of the dispute review expert to an arbitrator within 28 days of the written decision. Now, ordinarily the period of limitation would be 3 years. Now, this is abridging the time to 28 days. Why should that not be contrary to Section 28 of the Contract Act?
Absolutely, Your Lordship is right, because what 28 days is at best is the procedural compliance under the contract. It would not override the limitation as prescribed under the Limitation Act insofar as the lodging of claims are concerned. That wasn't the issue before the tribunal. The issue that my friend had raised is quite hilarious, Your Lordship. The issue was that
we'll come to that issue. We'll come to that issue later.
Your Lordship is right.
We'll come to that issue later. Now, Mr. Advocate.
Yes, sir.
When did you decide to challenge the DRB1?
DRB1 18 June 2018
was passed.
Yes, on that decision we said, if Your Lordship will see that later, my lord, 18th June 2018. That 11th June is, my lord, they invoked the arbitration at page 370.
Of the same volume?
No, volume 2, my lord. Page 370 is the notice given by the claimant with regard to DRB1 dispute, my lord.
370.
Annexure 32, my lord. And, my lord, at page 373, they nominate their nominees, my lord. And Your Lordship will note one more date, my lord.
Just a second. What are IPCs? IPCs?
Interim payment certificates which are given time to time. And 374 is the decision of the
So interest on delayed payment is very much a part of the claim.
Yes, this is the only claim, my lord. So far as
now, come to 11.0.
Yes, accordingly, we hereby request arbitration.
Number 3, it's one of the items of claim.
Yes, my lord.
Now, after that, how did you react to this letter?
This letter, my lord, is at 374, my lord. 374. Next page. 18 June. We said that we have decided to challenge this order. And then we not kindly see 375.
Letter of 18th June.
18 June. And kindly see 375.
And what was the DRB thing made?
The DRB decision was on 25/9/2016. First.
Very good, very good, very good.
And 374, my lord.
And so you rejected the arbitration thing?
Yes, my lord. But there is some more development at 375.
375?
Yes, my lord. What has happened? With reference to the subject cited above, I have to inform you that a meeting of the parties, that is State PW, Ministry of Road Transport and Highways, and contractor was held on 20th June at the office of Ministry of Road Transport and Highway Government. During the course of discussion, a consensus has emerged that you would revise your claim and submit the same to the Ministry Department of Road Transport, Government of India, and also the State PWD, Government of Meghalaya. Therefore, occasion has not arisen to the parties to resort to clause 25(3) of GCC with SCC 3. In view of the above, you are hereby requested to submit the revised claim as agreed.
What happened? By which letter did you nominate your arbitrator?
I did not nominate for this claim.
Where is your letter nominating an arbitrator?
My letter nominating my arbitrator, my lord, in respect of DRB2, my lord, is at page. This is a December letter, my lord, and 1511. Kindly see page 449. At 450, he gives the rebate of 25%.
Just a second.
And 451.
Just a second.
Sorry, sir.
This is rebate of 25% instead of 15%.
This is the letter, my lord. This matter ended here. Nothing happened.
Where is the appointment of the arbitrator?
451, my lord. Next page. This is with regard to DRB2 claim, my lord.
Where is the letter of 28/9/2018?
28/9/2018.
There is a reference in this letter to a letter dated 28 September 2018. Where is that?
That, my lord, is probably some. The details of updated due amount of 25/9/2016, 19/2. That letter is not on record. My lord, offering 10%, 15%, which was enhanced to 25%, my lord. This was happening with regard to DRB1, my lord. Now DRB2, my lord, is page 451.
Where is the letter of 28 September 2018 to which your reply at 451 has been issued?
That 451, my lord, 9/10/2018. This is the letter addressed by me to MORTH, my lord.
Where is
9/10 is, my lord,
your letter dated
9/10.
28/9. You're writing, Government of India, MOR is writing to Meghalaya.
Yes, my lord.
All right, that does not bind them. Where
Yes, my lord.
is your...
And then next page, 451. 16 January 2019, my lord.
You write.
I write forwarding a letter.
Where is your letter to the contractor nominating arbitrator?
My lord, page 451A.
This letter is not to the...
No, Mr. Your Lordship will see. Yes.
I am the forward copy of letter.
Copy under reference received from Ministry of so-and-so regarding the nomination of so-and-so.
To laning of Meghalaya to the road in such a...
And I forward the letter of MORTH.
Just a second. Reference 2012-2018.
That is 451, my lord.
2012-2018. Reference to above subject. Everything is included in the reference.
Your Lordship will see.
Rubbish.
You kindly see.
Everything is included in the
my
reference.
lord, with respect to kindly.
You're just wasting time.
Your Lordship kindly see. Kindly see.
Everything is part of the reference.
Your Lordship kindly see this letter 451 for my satisfaction, my lord. Please refer to your letter under so-and-so for dated for decision of the DRB of claim on contractor regarding delay, disruption and prolongation cost.
Where are you reading?
Page 451.
451 they are not bothered about.
This letter has been forwarded.
451 they are not bothered
Your
about.
Lordship kindly see their letter.
Your father, grandfather, they are not bothered about.
452, my lord. Kindly see 452 their letter.
451, you are bound by it. Everything is part of the reference. Rightly awarded. You deserve 18% interest.
Your Lordship kindly see 452 their reply. 452 to this appointment, my lord. 452. We are in receipt of your letter of 16 January to above serial number. Hereby we inform that appointment Mr. K.K. Jalan as your nominee arbitrator to adjudicate decision of DRB on claim of contractor regarding delay, disruption and prolongation cost only. And then, my lord, kindly see paragraph 90 at 454.
In which we refer all DRB decision pronounced with reference to the tribunal.
Now, however, while later we inform that appointed Mr. K.K. Jalan as your nominee arbitrator.
10.0.
10 point. Now, he refers
the fact.
Yes, my lord. Now,
we hereby refer all DRB decisions to.
Yes,
we nominate so-and-so as nominee. Further,
yes,
are requested to elect her.
Yes,
therefore,
sir. So now I nominate Mr. Jalan only for delay, disruption and prolongation. He nominates that all disputes will go before the arbitral tribunal. And arbitral tribunal assumes jurisdiction saying that...
What is your reply to this letter?
This letter, my lord, was not replied.
Bas, finished.
No, your lordship.
Over, game over.
This happened on, your lordship will see, this letter is of 19th. Now, whether by not replying.
This letter is of 1st of February.
Yes, 1st of February, and matter came before arbitral tribunal on 10th April.
Yes.
10th April, my lord. Then on 30th May 2019, he makes the claim and he puts both the claim.
Now, 10th April, these are minutes?
Yes, minutes, my lord.
Show us your submission on 10th April. What is the jurisdiction of the arbitral tribunal?
Will not the on 10th
April, show us what is your submission?
10th April, it was submission that he will make a claim, and I don't know whether he is going to include claim 1 or arbitral tribunal is going to.
Finished.
No, my lord, I will just give you a moment. My lord, there are two aspects, my lord. Okay. First aspect which has fallen from your lordship with regard to 28 days. Whether this is contractually, but I have a right to raise this issue or not. Arbitral tribunal said, all right, you can't go to the civil court, we will decide the matter. We have no, if your lordship does not accept this mechanism, then ultimately arbitral tribunal has to decide the matter whether the DRB claim.
Show us section 16 order.
Yes, your lordship. It starts at page 168.
Just a second, you have to go back. You have to record all this.
My lord, one submission, if your lordship is recording one submission, if I may, my lord. Lordship, the contractor says that I refer all the disputes to the arbitral tribunal. I nominate Mr. Srivastava. He will, and the arbitral tribunal will decide all. I did not make any reply to this.
Very well, you did not reply. The reference starts, you participate in the reference. In the reference, at the first hearing, you should say, stand up and say, your jurisdiction is limited only to the DRB2, not DRB1.
Yes.
Where is that said in your first reference?
Yes, my lord.
First minutes.
Then what is being taken against me is that in first reference I did not say the
problem is you take both sides.
No, I have taken only one side, my lord.
You take under the table also and over the table also.
My lord, this is a purely a claim which I will satisfy your lordship. I am sure your lordship I will be able to satisfy this.
No way.
Kindly see, my lord.
No way, waste of time.
I show, my lord. So first let me show the section 16, my lord.
You don't have to show anything else. First let us
section 16, my lord.
Letters.
Yes, your lordship. We'll see page 20.
First is there DRB1 reference. Where is that?
DRB1 reference is 11th June, my lord.
Yes.
11th June 2000. That is
DRB passed the order.
DRB passed the order on, my lord. First date is of 25/9/2016.
Just tell us where is clause 25 to page.
Clause 25 to page is, my lord, at page 225. Sorry, my lord. This is at page 255, my lord, at 262.
262,
my lord, of volume 1.
262, volume 1.
Yes, my lord.
Now come to DRB1 award. When?
That is of 25/9/2016.
25/9/2016. Now,
and my lord, DRB1 reviewed its award again because there is no power to review also on 19/2/2017.
19/2/2017 is both. Okay.
Yeah,
now,
this is DRB1, my lord.
This is DRB1.
Yes.
Now, show us their claim for reference, that 18 June or something letter.
11th June 2018 at page 370, volume 2.
11th June
2018,
page
370, volume 2.
370, volume 2.
June 2018 is my decision to challenge it, my lord.
Then
9th July 2018.
Just a second. Contractor invokes arbitration.
Yes, my lord.
Now that invocation of arbitration is not only for DRB1,
no, it
for
was
all.
No, because, my lord, at that point of time, DRB2 decision has not come. DRB2 decision came on 25/9/2018.
Very well. DRB2 25/9/2018. Very good. So 11/6. See Para 11.0.
370
Your
volume.
response is
18 June 2018, 374 volume 2.
Yeah. We reply 18th June 18, page 374, volume 2.
And then finally on 9th June.
No reply at all. And then 9th
July 2018, asking the contractor to withdraw the notice seeking appointment of arbitrator and reconciliate.
Just a second. We request withdrawal of 11/6/18 notice. That is on 9th July 2018.
374 volume 2. 375 volume 2, sorry.
375 volume 2. In view your requested revised claim anyway. Then comes
revised claim came on 15/11/2018.
What is that piece 376? 376?
376 is the recommendation of DRB2, my lord.
376 is DRB2.
DRB2. 25/9/2018.
Where do we find the date?
Date is, my lord, 25/9/2018 is that 376, volume 2.
Date is there?
Date is there, my lord.
Where?
At the foot of the page, my lord, I was having also difficulty in.
Where does this end?
This ends at, my lord, 376 starts and end at 3439. There at the bottom, my lord, 25/9/2018 is signed.
Yes, there.
Where are those pages?
Date at 439. Very good. Now come to your reference.
My reference is, my lord, which of 16 January 2019, forwarding the letter of ministry, my lord, at page 451A, volume 2.
Volume 2, page 451A. Subject is two laning of Shillong Nongstoin.
Shillong Nongstoin.
Rongren Road in so and so.
And forwarding the letter of my lord, 19th.
Nomination of arbitrator. So therefore the subject is for nomination of arbitrator.
Your lordship will read 451 also along, because
451 I will not read. 451 is your internal communication. The contractor cares 2 hoots for it.
Because, my lord, we have relied
on. This is where your people have taken money in writing these letters.
They have committed blunder. I know, my lord. But if I take it, my lord, that 452.
451 is with reference, so.
And 452 is his understanding also.
Reference by P. Now 452
is the reply, my lord.
Page 452. Reply by contractor.
Expanding the
1st February. This is dated 16 January 2019. And this is 1st February 2019. We are in receipt of your letter dated 16 January. Above number 9, whereby you were informed the appointment to adjudicate delay, disruption, prolongation.
Cost only.
Only, yes. So they've taken note of your letter with your.
Yes, my lord.
Then in this context, so and so, And finally, they say at clause 10.0
at 454.
that everything.
Yes, my lord.
Then, where is your reply? No reply.
No reply, my lord.
All right. Now let us take first minutes.
10th April at 456.
Page 456, 10th April 2019. Over here, nothing.
Nothing, my lord.
Nothing. No description of
anything, my lord.
Limited authority.
Because we do not know what authority the arbitral tribunal is going.
Now, where is your section 16?
Section 16 is, my lord, that 30th May, my lord, one more date, 30th May they file a claim. 30th May 2019.
May 30, 2019.
The claim is filed. Yes, my lord. Claim is filed, which is at page 460, including both DRB1, DRB2. Your lordship will just see that claim, my lord, at page 460, tabular form they have given at page 466.
At 466. Where is the claim on account of delay? Where is DRB1, DRB2?
Now, DRB1, my lord, that they have divided in two parts, my lord, and that is there, my lord. $476, my lord. And 478 is quantified, my lord.
What a coincidence. Both the decisions of DRB are on 25th September, 2 years apart.
No, yes, my lord, that's 25. The first decision is of 25/9/2016. There is a typo error in the 25/9/2016, my lord.
Yes, otherwise the corrigendum could not have come before.
Yeah, and corrigendum came on 19/2/2017, yes. My lord.
Where is your section 16?
In 575, my lord, that is dated 30th July 2019.
Page 5?
575, my lord, and 577. And 579, my lord.
Where have you specifically said DRB1? In your section 16?
Because, my lord, section...
Where have you said DRB 1 in your section 16?
Because this is the claim, with respect to, my lord, if your lordship will see 579, middle, claim number 1. Reclaim number 1, my lord, paragraph 6(1). And one by one we have...
Non-payment is also dispute.
Now, non-payment is also dispute, whether it's an arbitral dispute or not, your lordship may have
Absolutely arbitral dispute.
Because that arbitration mechanism is for 28 days only.
That's also arbitral.
Yeah, I bow down, my lord. Beyond that, I can't argue more.
Whether the claimant is subject to claims. No existence of dispute is admission. It's clear, unequivocal admission, no existence of dispute.
That is one. These have to be read or claim or barred by limitation, provision, agreement, my lord. You will see.
Finish it off. Exemplary cause. Exemplary.
You will see that. You will kindly see.
Exemplary cause.
You will kindly see the order, my lord. If the architect
judges to be fools,
no, my lord,
and you think that they are grazing outside, they come to court. Let us make a committee out of them.
No, not at all, my lord. If I can, I will show, my lord, this is nothing but, because if your lordship take it that arbitral tribunal has jurisdiction to decide. I have no issue, my lord. Let arbitral tribunal decide my issue also. Whether the arbitral tribunal has decided the issues which I have raised. Your lordship kindly see the finding, of the finding in this regard, my lord. Page 168 of paper book, my lord. Appeal, paper book. Sorry. Sir, volume 1 only, your lordship kindly.
Volume 1?
Volume 1, my lord.
In volume 1 you have that?
Yes, I have placed everything, lord.
Page?
Page 168. 168. And the finding, my lord?
Yes.
At starts paragraph 24.
No, where do they say we'll consider it later?
Yes, your lordship. That your lordship will find and 46, para 46 at page 254.
46.
Oh, sorry, page.
Filing application of section 16 remains silent. Admitted respondent till the filing of the application and thus it will be amount to acquisition to notice 1/2/2019 is the one exactly what we had said. And this would amount to, now it does not lie in the 46, no. Even if it is assumed, this is, have not been respondent. Yes.
49, 195.
49.
Yes, my lord. 45, 46.
Paragraphs. What is the date of the section 16?
This is the order dated, my lord, is 21/3/2020.
21/3/2020. Page 168, volume 1. And relevant paragraphs are 46 at page 194.
49.
46 and 49 you say?
49. It is well settled. The question of limitation is a mixed question of law and fact and law. Moreover, there are tribal issues in the present case since the respondent has not payment to the claimant in terms of DRB 1 and DRB 2. Thus, there has been no final settlement between the parties. Therefore, such disputes are to be considered by arbitrator and not by civil court. On this point, we are supported by the following decision. So, they will they decided that they have...
Where?
Fair enough.
Where do they say we will decide?
Therefore, such disputes are to be considered by arbitrator.
Yes.
Not by civil court.
Yes. So, where do they say we will decide in future?
No, first question of law and limitation is mixed question of law and fact. There are tribal issues in the present case since the respondent has not made payment in so and so. Thus, there has been no final settlement. Therefore, such disputes are to be considered by arbitrator, not by civil court.
Yes.
So, what I take it, my lord, my understanding, limited understanding, is that at this stage in 49, when authoring paragraph 49,
costs enhanced.
Your Lordship, kindly see now.
This is deliberately misleading.
Your Lordship, your Lordship will see what we want is that even the arbitral tribunal should kindly see award, my lord.
Anything else?
No, Your Lordship, kindly see award, my lord. There is one.
What award?
Award pass on 31/6 on the ground that Order 12 Rule 6. Now you take 75 crore rupees. Claim was allowed, my lord.
Where do they get that 75 crore?
There is no basis, Your Lordship, nothing.
Where is that?
Your Lordship will see that.
Award?
Award is also there here, my lord. Within the volume 1 only, my lord.
Yes.
And that award is at page 137.
What is the date of the award?
That is the date is 27/7/2021.
27/7/2021.
Yes, my lord.
Volume 1.
A2.
Where do they get the figure of?
Your Lordship will see at the last page of this award 101 paragraph 101, my lord.
101.
Sorry. That goes to, yes. '98. Accordingly, we have no hesitation in holding the present.
Second. You're reading 98.
In 98, my lord, start from page 165, 98.
What does 31/6 provide for?
31/6 is that the power of the arbitral tribunal.
Yes, give us the Arbitration Act.
Arbitration Act. Yes.
(31)(7) is probably interest.
Yes, madam.
At any time during the arbitral, make an interim arbitral award. Make a very good interim arbitral.
Yes, madam.
Interim award. Very good. Yes, Uttam Singh Duggal is the final case on that matter.
Yes, Lord, that's not a dispute. Kindly see.
Uttam
One
Singh
paragraph,
Duggal
one-
is the best case on
the
admission.
Yes, my lord.
Just-
Page 151, your lordship see paragraph 56 first, my lord. Findings start. Finding.
Where do they get the figure of 75 crore?
Your lordship will see page 101, paragraph 101. Accordingly, we partly allow the present application under section 31(6). 1.
It is noted DRB 1 decided the amounts we paid on calculation basis of 12%. Various calculations made by India on simple interest, though at some places interest and exchange to note the dealings tried to justify the monthly component not certified by the criminal can simple XYZ to present So it's made a rough and ready approximation.
Your lordship kindly see, and then what they say is that nothing, 104, nothing expressed in this order shall an opinion on merits of the present case. And your lordship will see page 151. Paragraph 56, my lord. At the outset, we may point out respondent in reply to present when raised numerous objection. Same very objection was enumerated in section. We have already dealt with such objection and our order dated 1/21/3/2020. While dismissing, none of my objections have been on merit has been dealt with. This arbitral tribunal is not going to consider such application under 31(6), my lord. Your lordship kindly see what my argument is, my lord. Your lordship kindly give me some.
You're paying, you want.
Your lordship give me some more time to.
50 lakhs as of now. As much
I'll pay your lordship if I prove wrong, my lord. I will pay whatever cost your lordship will impose. I will pay, my lord.
End this right now.
No, your lordship kindly.
This is
No, Your Lordship will.
This is
what has happened.
A complete waste of time.
Your Lordship, kindly give me
and a reckless exercise conducted by.
Your Lordship, kindly see what I will show.
A government litigant.
No, my Lord, this is not a case where, my Lord, I will show, my Lord.
Thank you.
No, Your Lord,
take your seat.
You kindly see one.
Thank you, sir. Please take your seat. The challenge is under Section 37 of the Arbitration and Conciliation Act 1996 to an order dated May 17, 2023, passed by the Commercial Court Shillong on a plea under Section 34 of the Act challenging an arbitral award rendered on July 27, 2021. Full stop. Paragraph. The arbitral award was made in an application under Section 31(6) of the Act. Full stop. Such provision empowers an arbitral tribunal to pass an interim arbitral award in respect of any matter that may be covered by a final arbitral award. Full stop. Paragraph. The appellant herein engaged your PWD National Highway
Yeah, my Lord.
of Meghalaya.
Yes, my Lord.
Appellant herein engaged the respondent for four-laning of the Shillong to Nongstoin and beyond, possibly up to Tura, highway, full stop. The claims in the reference pertain to the delay, disruption and prolongation of the contract, together with interest on account of delayed payment and the like. Full stop. There is no dispute that there was delay in the execution of the contract, and the appellant herein submits that it was for such reason that the value of the contract has been revised and claims on account of interest and the like for previous delayed payments have been subsumed in the enhanced value of the contract. Full stop. Paragraph. The contract itself provides for a two-tier mechanism for the resolution of disputes. Full stop. In such context, clause 25 of the contract is of some relevance. Set out clause 25 from page 26 2 of volume 1. We are marking the page.
My Lord, this 274D also have got. No,
what is that?
25(3), the mechanism for appointment.
No, it's there. 25, 1, 2, 3, all are there.
3 and plus 3, special conditions of contract, my lord. That is 25.
Paragraph. An initial claim, no, the dispute, no, please cut it out. Despite the value of the contract being enhanced, comma, the contractor sought to assert a claim on account of delayed payment of its regular bills. Full stop. In accordance with clause 25 of the contract, the dispute review expert board considered such claim and, comma, rendered and by a reasoned decision passed on September 25, 2016, comma, found that the contractor was entitled to a substantial sum. Upon the contractor requiring the dispute review expert board, DREB, requiring to re-examine its claim, since several aspects of the delay had not been accounted for, comma, a revised decision was passed by the DREB on February 19, 2017, finding that the contractor was entitled to a sum in excess of rupees 117 crore on account of delayed payment, on account of interest for delayed payment,
interest of delayed payment and some bitumen unpaid amount.
And some amount on account of unpaid bill for bitumen. Full stop. In accordance with clause 25.2 of the contract, such decision of the DREB ought to have been challenged by the appellant employer within 28 days, full stop. However, comma, even if it be accepted for argument's sake that the abridgment of the time would fall foul of section 28 of the Contract Act, comma, what is evident is that there never was any challenge at all to such decision of the DREB of February 19, 2017, which incorporated the earlier decision of September 25, 2016 within its fold. Full stop. Paragraph. On the remainder of the disputes between the parties pertaining to delay, disruption and prolongation of the contract, comma, a separate decision was rendered by the DREB on September 25, 2018. Full stop. Paragraph. Prior to the second decision of the DREB being pronounced on the delay, disruption and the prolongation aspect, comma, since the amount awarded by the DREB on February 19, 2017 remained outstanding for a long time, the contractor wrote to the appellant herein on June 11, 2018 seeking arbitration. Full stop. The relevant letter at paragraph 11.0 thereof specifically invoked clause 25.3 of the agreement, read with the relevant clause of the special conditions of contract, and the dispute described in such paragraph pertain to 4 specific heads: additional usage of bitumen, reimbursement of labor cess, interest on delayed payments, and interest on delayed payments. Full stop. Paragraph. It would appear that the interest on delayed payments, the claim on account of interest of delayed payments, included the quantum awarded by the DREB, as there is reference, earlier in the said letter, to the DREB decisions of September 25, 2016 and of February 19, 2017. Full stop. Paragraph. In response to the contractor's letter of June 11, 2018, the appellant claimed that the appellant was open court to appeal against the order of the dispute review board, and the matter is being communicated to the DRB accordingly. Full stop, close quote. This assertion made no sense at all and was completely contrary to clause 25 of the contract between the parties that required the dispute to be carried within a specified period, full stop. Even if such specified period is ignored, a dispute had to be raised and the appellant had to carry such dispute to a logical conclusion. Paragraph. Since the agreement between the parties provided for arbitration as specifically recorded in clause 25.3 thereof, read with the special conditions of the contract, the only meaningful way in which the appellant could have disputed the DREB decision of February 19, 2017 bracket, which included the earlier decision of September 25, 2016, bracket close, was by referring the matter to arbitration, full stop. Till date, no such step has been taken by the appellant in such regard, full stop. Paragraph. On the contrary, comma, on some frivolous grounds that the contractor need not have taken into account at all, comma, the appellant wrote on July 19, 2018 for the notice of June 11, 2018 to be recalled, full stop. The appellant has not been able to demonstrate that the contractor withdrew such notice, full stop. By the appellant paragraph, by the appellant's letter of January 16, 2019, a reference was made to arbitration. It may do well to notice the entirety of such letter from where it quotes the subject till where the substance of the letter ends, colon, set out as indicated. Paragraph from page 451, capital A of volume 2. Paragraph. It is evident that the reference that was made, it is evident that the nomination of arbitrator that was made was in respect of the matter covered by the subject referred to in the relevant letter. The subject was, comma, quite clearly, comma, Nongstoin section of NH 44 and Nongstoin Rongleng Tura State Road, ... There is no doubt that the relevant letter of January 16, 2019 referred to a letter dated December 20, 2018 that had been received by the appellant from the Union Ministry of Road Transport and Highways. And it is equally possible that a copy of such letter was also forwarded by the appellant to the contractor, full stop. However, comma, what cannot be missed is that the nomination of the arbitrator was in respect of the subject matter which was clearly indicated in the letter, though the letter also carried a reference to the previous letter received from the relevant union ministry. Full stop. Paragraph. The contractor responded to such nomination of arbitrator by the appellant by the contractor's letter of February 1, 2019. Full stop. Much is sought to be made out by the appellant of the first paragraph of such letter of the contractor, which reads as follows, open quote, we are in receipt of your letter dated 16/01/2019, cited above at serial number 9 SL number 9, S is lowercase, whereby we were informed the appointment of Mr. KK Jalan IAS (retired) R capital bracket close as your nominee arbitrator A capital to adjudicate on, then open quote, D capital, decision of the DRB on claim of the contractor regarding delay, disruption and prolongation cost, close quote only, full stop. The contractor's reply paragraph thereafter, thereafter proceeded to record the history of the relationship between the parties, culminating in a request made at paragraph 10.0 to the effect that all the decisions of the DRB were to be referred to the arbitral tribunal, full stop. A table-form chart was included in such paragraph, and the claims indicated included interest on delayed payments and interest on delayed payment for bitumen, two matters that were covered by the DREB decision of February 19, 2017, bracket, including the previous decision of September 25, 2016, bracket close, full stop. Paragraph. Significantly, the appellant herein did not respond to the letter of February 1, 2019 and the contractor's request for all disputes to be referred to arbitration. Full stop. Paragraph. It was in such circumstances that the arbitral tribunal came to be constituted with the two nominees of the two parties and a third arbitrator who was appointed in accordance with the agreement between the parties. Full stop. At the first sitting of the reference, reference held on April 10, 2019, copious minutes have been recorded, full stop. However, there is no suggestion or clarification by the representatives of the appellant present at such meeting to confine the terms of reference of the arbitrator to only the claims on account of delay, disruption and prolongation of the work, or to exclude the claim on account of the decision of the DREB rendered on February 19, 2017, bracket, including the earlier decision of September 25, 2016, bracket closed. It was only after the claim was carried, paragraph, to the arbitral reference by the contractor in the end of May 2019 that a Section 16 that an application under Section 16 of the Act was filed by the appellant herein. Full stop. Such application was filed on July 30, 2019. Full stop. It is necessary to ascertain the scope and purport of the relevant application from the pleadings therein. Full stop. At paragraph 2 of such application, the appellant exhorted that the arbitral tribunal could acquire jurisdiction only in the manner laid down in the contract between the parties, and further asserted that the claim which had been raised by the claimant but had not been referred to arbitration in terms of the contract could not be entertained by the tribunal. Full stop. Despite the appellant having nominated its person on the arbitral tribunal, the two nominees of the parties having decided on the third arbitrator in accordance with law, and no objection raised by the appellant, not only at the first hearing in the reference, but for a period of 3 months, more than 3 months thereafter, the appellant finally claimed in the relevant application that since there was no dispute between the parties in terms of in respect of the decisions rendered by the DREB on September 25, 2016 and February 19, 2017, such claim carried by the contractor to the reference was not arbitrable. Full stop. Indeed, it is necessary to see the exact words of the appellant used in the relevant application, without the subparagraphs that followed. 6, full stop, paragraph 6, within inverted commas. It is respectfully submitted that the claimant is liable to be non-suited on each of the above preliminary grounds, which are more particularly detailed hereinafter, After that, 1, full stop, all cap, in re, claim number 1, up to that all capitals. Then, claims relating to the due payable interest on the delayed / late payments of IPCs, IPC apostrophe A, small s, and accrued payable due interest on principal amounts awarded and paid to the claimant, C capital, by the respondent, as per the decision of the dispute committee, dispute review board, dated 25 full stop 09 full stop 2016 and 19 full stop 02 full stop 2017 full stop all of this in underline from in reclaim. Paragraph number 1 is not underlined, but in reclaim everything is underlined. Then next, under this, A, no bracket, A full stop, everything bold, and underlined. No existence of, within colon, dispute, close quote, in terms of provision of contract warranting invocation of dispute resolution process, colon, next line, dot, 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 close quote. Thus, comma, what is evident from the relevant application is not any assertion that the dispute pertaining to the non-payment of the sum as decided by the DREB on February 19, 2017, bracket inclusive of the amount as decided on September 25, 2019, bracket closed, was concerned, but that since no dispute in such regard had been raised by the appellant, comma, there was nothing to adjudicate on in such regard in the arbitration. Full stop. Paragraph. Classically, comma, at one stage, it was also the understanding in law that mere non-payment without any attempt to justify such non-payment would not be a dispute which would be covered by an arbitration agreement to be referred to a reference. Full stop. However, comma, the understanding in such regard has undergone a transformation over the last century or so, and mere non-payment now also amounts to a dispute since, comma, without adjudication thereof, comma, despite there being no dispute, comma, the party claiming the money has no recourse to the same without an arbitral award, without as any recourse to the same, full stop. Paragraph. What is even more significant is that the appellant herein admitted categorically and unequivocally that it had not raised any dispute in respect of the DREB decisions of September 25, 2016 as modified, DREB decision, not decision, decision as modified by the subsequent order of February 19, 2017. Full stop. In clear words, comma, the appellant herein admitted, accepted and acknowledged that it was liable to pay such amount semicolon, only that the arbitral tribunal could not go into it since such matter, since there was no dispute in such regard, and comma, as a consequence, comma, the matter was not amenable to arbitration or any form of adjudication. Full stop. Paragraph. In the light of the nomination made by the appellant herein in its letter of January 16, 2019, and the subject matter therein covering the entire relationship between the appellant and the contractor, comma, it was a possible view that the arbitrators could take, full stop, It is not necessary in this jurisdiction to hold that the view taken by the arbitrators was the correct view or the only possible view. Full stop. It would pass muster if it is recognized that one of the possible views was taken by the arbitrator. Full stop. By the arbitrators. Full stop. Paragraph. In addition, comma, it must not be missed that the immediate response of the contractor, comma, in its letter of February 1, 2019, comma, was to call for all the outstanding matters to be taken to the reference, full stop. To this, there was no reply from the appellant, full stop. In the backdrop of the contractor's letter of February 1, 2019 and the complete lack of response thereto by the appellant herein, comma, the arbitral tribunal was constituted and it was possible for the arbitral tribunal to assume that the entirety of the disputes between the parties pertaining to the transaction had been referred to such arbitral tribunal. Full stop. Paragraph. The award that was rendered and which is challenged in the present proceedings was made on July 27, 2021. Such award was made under section, following an application, following an application by the contractor under section 31(6) of the Act, full stop. In the award, comma, the arbitral tribunal reckoned that since no dispute had been raised at all by the appellant in respect of the decisions rendered by the DREB on September 25, 2016 and February 19, 2017, comma, the appellant herein could no longer object to the total amount decided in favor of the contractor being made the subject matter of an award. Paragraph. Indeed, comma, if one were to be hypercritical, comma, one would question why the arbitral tribunal went into the issue of interest on interest and duplication of interest, since such matter had never been canvassed by the appellant herein upon the appellant failing to raise any form of dispute to the two decisions of the DREB passed on, made on September 25, 2016 and February 19, 2017. Full stop. Paragraph. The appellant seeks to distort the order passed on March 21, 2020 on its application under section 16 of the Act. Full stop. At paragraph 46, of the relevant order, the arbitral tribunal observed that till the date of the appellant herein filing its application under section 16 of the Act on July 31, 2019, it remained silent, open quote, and thus it would amount to giving acquiescence to notice dated 01 full stop 02 full stop 2019 for consolidation of both the claims. Full stop, close quote. It is evident that the arbitral tribunal read the conduct of the appellant herein exactly as this court has done, in inferring that upon the appellant herein not responding to the letter of February 1, 2019 and not indicating the bounds of the arbitral tribunal's authority in course of previous hearings in the reference, the authority of the arbitrator extended to the entirety of the transaction between the parties, full stop. Paragraph. Again, paragraph 49 of the order dated March 21, 2020 is sought to be distorted, is sought to be twisted out of context by the appellant, as the appellant suggests that such paragraph held out a promise by the arbitral tribunal to adjudicate on the disputes pertaining to the claim on interest at a later stage, semicolon, but while passing the award, impugned award, on July 27, 2021, the arbitral tribunal quite facetiously indicated that the matter had already been decided in its previous order of March 21, 2020. Full stop. It is necessary that the relevant paragraph be seen in its entirety, colon. Set out paragraph 49 from page 195, volume 1. Full stop. It is clear that what the arbitral tribunal sought to indicate in the relevant paragraph was that there was no final settlement between the parties by payment and accord. Full stop. The arbitral tribunal also noticed that no dispute had ever been raised by the appellant pertaining to the claim on account of interest which called for an adjudication. Full stop. The arbitrators finally held that in view of the arbitration agreement contained in the matrix contract between the parties, there was no mandate for either party to approach any civil court, as all disputes had to be finally decided in accordance with the arbitration agreement and not otherwise. Full stop. There is no element of promise held out in the relevant paragraph that the matter pertaining to interest or any purported dispute in such regard would be considered at a later stage. Full stop. Paragraph. The argument appears to be a figment of the appellant's imagination. Full stop. Paragraph. Here is a case of a contract being stretched beyond its original period and payments not being tendered within reasonable time. Full stop. There was a procedure which was established, a mechanism which was established in the agreement and the contractor succeeded by obtaining favorable decisions from the authority that was tasked with such duty to adjudicate within the framework of the contract. Full stop. Indeed, there are letters on record which reveal that the contractor offered to give up a substantial part of the amount that had been adjudicated in its favor by the DREB and even enhanced the quantum of rebate. If only to prompt the appellant to making immediate payment. Full stop. However, the appellant did not relent. Full stop. Paragraph. There are other specious excuses which are proffered in this matter, which has been a complete waste of judicial time. Full stop. Notwithstanding the contract being between the appellant and the contractor, a fact which is clearly admitted, the appellant refers to correspondence is exchanged with the relevant union ministry and the advice that it received from such ministry. Full stop. In a contract between two parties, neither is governed by the conduct of a third party, whatever may be such third party's control over the other party. Full stop. Indeed, an issue has been sought to be raised quite seriously that the Union Ministry of Road, Transport and Highways was a necessary and a proper party to the present proceedings. Full stop. Surprises never cease. Full stop. It is probably because the officials who are behind the appellant do not need to pay from their own pockets, and it's the taxpayers' money that is being wasted. Full stop. Paragraph. The court of the first instance was perfectly justified in not touching the award. Full stop. The award rendered on July 27, 2021 is unimpeachable, it is based on the clear and tacit admission on the part of the appellant herein, and the appellant could never have turned around to question its own admission or seek to deny payment of what was found by the DREB on February 19, 2017, including the decision of September 25, 2016, close, to be due and owing to the contractor. Full stop. In making the interim award, which is equally executable as a final award, the arbitral tribunal has only given the contractor a part of its due that had remained outstanding for a long time. Full stop. The court of the first instance, quite appropriately, quoted relevant paragraphs from the impugned award with approval and observed that the same did not call for any interference. Full stop. Paragraph. It has become fashionable, particularly for public sector undertakings and government litigants, to throw sheafs of paper at the court and believe that such tomes would dissuade judges from looking deep into the matter and be frightened enough to grant an adjournment and delay the inevitable. Full stop. It is time that litigants don't bark up such wrong trees. And the only way this can be ensured is by imposing reasonable and rational costs for such misadventure. Paragraph. Arbitration appeal number so-and-so are dismissed with costs assessed at rupees 10 lakh, which will be paid over and in addition to the amount awarded. Full stop. Paragraph. The tragedy is not in the appellant as a litigant seeking to not disburse the payment, semicolon. The tragedy is in the erroneous advice that is rendered to litigants as the appellant. Thank you.
Oblige me. Not cost part, my lord, they have bought 75 crore plus 12% interest on interest.
If I had my way, I would give them the 75 lakhs as costs to dissuade such things being carried out in court. This is a shame. This is a shame that this has happened in court. And you'll appreciate the last line, Mr. Advocate General.
Yes, sir.
Yes, call on the next matter, please.
From the main list, item number 1.
Lordship, Lordship.
Yes.
Matter may be taken up, Lordship, after 2 weeks, Lordship.
What is the matter? At the request of the, you're the appellant or writ petitioners?
Writ petitioner, my lord.
Let the matter appear a fortnight hence. Yes.
Item number 2.
When do we start? When do we finish?
I'll take some time, my lord.
Yeah. When? Tell us.
Maybe after 2 weeks, my lord.
After 2 weeks?
After 2 weeks, my lord.
Very well. Let the matter appear a fortnight hence. There are 2 matters, no?
2 matters.
This is that 302.
364 and 302, my lord.
Recovery of the dead body at the instance of the accused of the
That's
appellant.
section 27, my lord.
This is that in that Riboy jungle.
Yes, Gwalpara, Assam.
Yes. Okay. This is open and shut.
I'll try my level best to convince.
Yes.
Item number 4.
The